Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we are pleased to have all of you here today, and we'll begin with Kimberly Polk versus the Montgomery County Schools. And Mr. Claybrook, whenever you're ready, sir.
Thank you, Your Honor, and good morning to you all.
I want to ask everybody to speak up, and that's not because your voices are too low, it's just because my hearing is not what it should be.
I'm right with you. I've got my hearing aids up all the way, but sometimes I still don't hear very well. So we will speak up. And this morning, I'd like to focus on two ways in which the U.S. Supreme Court's decision in Mahmoud versus Taylor this past June relates to Ms. Polk's free exercise and free speech claims.
I've got some questions about jurisdiction. How do we have jurisdiction here to consider the merits of those constitutional claims? You're not here on a final order.
Wait, this is an appeal from a district court case.
You're not here on a final order.
We're here on a denial of the preliminary injunction, Your Honor.
You are.
So that provides our jurisdiction. And after discussing Mahmoud, I'd like to bring to this court's attention some other recent developments in the Supreme Court that are relevant to this case. Now, let me take free exercise first.
And that aren't in your, anything that you've filed with the court so far?
We filed a supplemental.
Okay, so that's what you're going to talk about.
Yes.
I just want to make sure the opposing counsel in the court isn't unfairly surprised by what you're about to argue.
We filed a supplemental authority letter on Mahmoud, and they responded to that, Your Honor.
Mm-hmm.
But that Mahmoud was decided in late June, which is after our briefing was totally completed in this case, formally.
But the injunction is only denied under the judge's opinion on the Title VII claim.
Yes, the Title VII claim is
The
still
Title VII claim, and that's what I'm getting at. How do we get to the merits of the constitutional claim on a preliminary injunction appeal? You do have a preliminary injunction appeal, that's what it is.
Right.
1292A1, I think it is.
And we're not raising the Title VII issue, which
Well, but
the
that's
district
where
court did not
but the judge talked about denying the injunction on the Title VII claim and dismissed the merits without prejudice.
Yes, but she dismissed the order.
But on the injunction, they only have to assess the likelihood of success.
Yes. And she dismissed it without prejudice.
Without prejudice.
That's right.
And denied the injunction on the basis of lack of irreparable harm as to the Title VII claim. It's the way I read the judge's opinion on page 38, 39
Right, she's not.
of the opinion.
Right.
So that's what I'm concerned about. I just want to alert you. You can argue however you want, but I'm concerned about what we have, whether we have jurisdiction to assess the issues that you want to argue about.
Right, but she said that we had no claims. She dismissed the claims with respect to free speech and the free exercise claims, and that's what we're appealing here. Now, on the free exercise.
Well, the injunction or the denial thereof would go to the whole law, would it not?
I'm sorry, I didn't catch it.
The injunction or the denial of the injunctive relief would go to the whole law, would it not?
Would go to the whole law?
As to whether the law was valid or whether it was not valid.
Yes, the policy we're talking about, yes. it would go to the parts of it that Ms. Polk has objections to, and for the reason she was fired. She said she wouldn't follow them. Am I,
What, with respect to your free exercise clause claim, wouldn't we be jumping a little bit ahead of the Supreme Court if we've vindicated your position on free exercise?
well, that's part of what I want to talk about. The Supreme Court has given you another issue to decide. Because in Mahmoud, they said they were confronted with the Smith defense. The district court denied the free exercise claim here because she said that Smith's rule saying that there's no free exercise violation if we're dealing with a law that is neutral.
But this is a law that makes no reference to religion at all. At least on its face, it seems perfectly neutral. And in that event, wouldn't it be covered by Employers Division versus Smith? I mean, I realize that there have been a number of justices that have expressed reservations about that decision, but it hasn't been overturned.
Yeah, we think it's very clear that under Lukumi and other cases that have discussed the Smith case, that you have to decide, well, even though it's neutral on its face, is it really targeting religious action? And I think that's very clear here, that we're dealing with.
You say that repeatedly in your brief and now today, that it's very clear that it's targeting religious action, even though the word religion appears nowhere in it. So it's not very clear to me that it's targeting religious action.
Well,
How do you make that argument?
Well, you can use common sense. It's those who have traditional.
Apparently I have none, because it's not
well,
very clear
but
to me.
Well, the Supreme Court says, you can know whether something is targeting religion. I mean, they use an
You
extreme
brought up
example.
Lukumi and as a way to know whether something is targeting religion. In that case, it's much different than this one, because there were comments by the lawmakers disparaging the particular religion that was targeted, and the ordinance itself was focused at animal sacrifices versus all animal killings and things like that. There's nothing of the sort here, is there? If there is, I'd be happy
No.
for you to point me to it in the record.
No, there's not. But
Okay.
on the other hand, it also says in those cases, you have to look to see if it really is targeting religion, and if religion is predominantly affected by this regulation. That's
How
what-
is religion predominantly affected by this regulation?
Well, you can take a look at Mahmoud itself. It was brought by parents of different faiths, all traditional religions.
You're assuming, I think, that only people of faith might have any issues or concerns with the ordinance. There could be secular reasons why people would have concerns with the, I'm sorry, not ordinance, with the policy.
And I don't challenge that at all, Your Honor, but it's also true that it's predominantly affecting,
How? Based on what in the record?
well, I'd refer you to the Bates decision or the Ninth Circuit recently.
No, but in the record of this case.
I don't have a statement that says it's based on religion, and religion is not stated, as Judge Wilkinson said.
Well, but I mean, to follow on Judge Thacker's question with respect to this, the law on its face is perfectly neutral, and it makes no reference to religion at all. And it covers issues that are secular as well as sectarian. It's a generally applicable law, and it made me a little bit nervous because the Supreme Court, although several justices have indicated an uneasiness with Employment Division v. Smith, they haven't overruled it, and until the Supreme Court overrules it, It's not our job to jump out in front of the Supreme Court and knock it down on free exercise grounds. It's possible that your free speech claim was the more interesting one. I was surprised that you led with the Employment Division v. Smith and didn't talk about the free speech claim. Why don't you talk about that?
We tracked what the district court did, Your Honor. But I will talk about that, but I do want to also point out that, first of all, we do not agree that this is generally applicable. There's discretionary judgments that the school district can use, which brings it under the Fulton rule. We discussed that in our briefs. But also, I want to point out that Mahmoud gives you another issue that you have to decide, because the school district in Mahmoud also brought up Smith as a defense, and the Supreme Court said, listen, when a law is like Yoder, Yoder was distinguished in Smith, and so Smith doesn't apply and doesn't even have to be considered. So the operative language in Mahmoud is, when a law imposes a burden of the same character as that in Yoder, strict scrutiny is appropriate regardless of whether the law is neutral or generally applicable. So applying that here, Yoder
Yes,
dealt with the education
I
of children.
think the concern that we're having, and I don't think you're picking up on it, is that people for very secular reasons that have nothing to do with religion can take one view or another with respect to issues surrounding transgender status, and that's very significantly a secular debate, and so
I don't second guess or denigrate that, Your Honor, but the point I'm making is Mahmoud says you don't even have to think about those issues if this is a case that's like Yoder, and we think it is like Yoder all the way down the line. We're dealing with education of children, we're dealing with parents who disagree about how the school district is treating their children and what they're teaching them. And
Did she bring this lawsuit as a parent?
she brought it as a teacher, Your Honor.
All right, so what standing does she have to assert some parental right argument?
She has standing because she is refusing to lie to the parents about what's happening
Lie.
at school.
And you use lie repeatedly in your briefs too. Just like the word religion is nowhere in this policy, neither is the word lie. And if it is, please show me.
The policy does not use the word lie, but it's
Okay,
telling the teachers to mislead parents about what is happening
And
at
it
school
also
not
does
to
not
tell them.
use the word mislead, does it?
It doesn't use that word. It says, don't tell them.
It
Keep
says-
it secret. Keep it private.
No, it doesn't use the word secret either. It uses confidential information for the safety of the child if the child is in a home that is unsupportive.
That's correct.
Is appellant unconcerned with the safety of the students in her classroom?
Oh, of course she is.
Well,
But- but
that's what
it's-
this policy is about. That's what it says right at the beginning.
Well, what's happening here is that the school district is deciding what's in the best interest of the children instead of the parents, and telling teachers not to tell
Apparently,
parents
appellant
what
is trying to decide what's in the best interest of the students rather than the parents or the school board.
No, that's not what's happening, Your Honor.
That's what it
she's
sounds like
refusing that.
based on your argument. And Judge Wilkinson tried to direct you, I think, attempted to direct you to your second argument about her freedom, her First Amendment freedom of speech argument. You don't have much time left at this point. Would you like to address that?
I will. Thank you, Your Honor. Mahmoud also relates to the free speech, and of course, the school district claims that this falls under the Garcetti rule for government speech, and we explain why it does not. But Mahmoud is relevant to one of those reasons in particular, and that's the statement in Garcetti, reinforced by the Supreme Court in Janus, that the government can't compel the speech of employees for an unlawful or otherwise inappropriate purpose. In Mahmoud, the Supreme Court found that the school district using LGBTQ affirming books with kids was unlawful if done without the parents' knowledge and consent. How much more so here? The school district here has ordered Ms. Polk to conspire with it to hide what's happening in school from parents with respect to how their own child is named.
If we are thrown in, if we are thrown into the Pickering balance, which I know you want to move past Garcetti and into Pickering, wouldn't the school district would still have an interest in protecting a child from bullying by one's classmates? That's a significant state interest in this instance, and to not, and the state is contending that by not calling attention to gender identity or whatever, that, or using the student's preferred pronoun, that they are protecting the student from harassment and bullying by one's peers. Is that not a legitimate state interest?
It's just not an interest that's involved in this case, Your Honor, because Ms. Polk certainly is not going to be involved in bullying. She said she'd stop any bullying that she found or saw that occurred, and she's going to treat the children respectfully. So it's just not an interest that's involved here.
Unless respect includes using their preferred pronouns.
Except for, I'm sorry, Your Honor, one more time?
Unless respect includes using their preferred pronouns.
That's correct. She'll use their preferred name, but she would just not use.
Well, what
use
if
the pronoun.
what if they're a student is biologically female and the student's preferred name is Robert?
She says she'll use it. So, because nicknames are, it doesn't violate her religious beliefs, but calling her he is a problem for her. Right. All right, my time is up. I did want to mention some recent Supreme Court developments that are relevant, but I can put that to the side for now.
Do you have any questions?
Fine.
No, I'm good.
We're fine, thank you. You have some rebuttal time. Ms. Mitchell, we're happy to hear from you.
Good morning, Your Honors. May it please the Court. This is an appeal from the denial of a preliminary injunction on 2 constitutional claims. The question before this Court is whether the District Court abused its discretion. It did not. On the free speech claim...
What about the jurisdiction? What do you say about that?
Your Honor, at the
I
end
mean,
of...
it's an interlocutory appeal.
That's correct.
There's no final order.
Our understanding is that plaintiffs have appealed the denial of their preliminary injunction. At the end of Judge Boardman's order, she did deny the preliminary injunction in full. So that's our understanding of the basis for the plaintiff's appeal. But we agree there is still the Title VII claim proceeding below in the District Court.
Well, that's an appealable issue, either a grant or a denial of a preliminary injunction. We've got an appealable order, and I understand it, on this issue, rather than go through a bunch of hoops, you'd like to have some kind of judgment on the constitutionality of the law so it can be settled.
That's correct, Your Honor. The school district is prepared to make argument on the constitutional claims at issue.
You know, the school district needs to know, and the parents need to know, and students need to know, and teachers need to know. There are a whole lot of people, whichever way we come down, that would like, or the Supreme Court would like to know, rather than kicking the can down the road indefinitely.
That's correct, Your Honor, although we would say this is only an appeal of the preliminary injunction finding. So to the extent the court, the court can make a decision based on that standard of review rather than the motion to dismiss standard, and Ms. Polk is free to raise an appeal of that motion to dismiss decision.
So the
down
issue is
road.
likelihood of prevailing on the merits,
That's
not
correct.
the merits itself.
That's correct, yes. Because this is only an appeal of the denial of the preliminary injunction, not the motion to dismiss decision itself.
And the district court didn't specifically rule on the likelihood of prevailing on the merits.
That's correct. The district court's decision addressed the motion to dismiss first, but then in the end said because it found the claims could be dismissed, it would deny
So
the
you're saying that
preliminary.
addressing the merits necessarily encompassed ruling on the likelihood of prevailing on the merits?
I think that's correct,
And there-
although,
And there's,
yes.
and there's precedent, even in our circuit, for addressing issues like this that are inextricably intertwined with the issues relating to the injunction. So that might be the basis that you'd want to think about. That the jurisdictional hook, nobody addressed the jurisdiction, I don't think, in the briefs. You talked a lot about the Constitution and the free exercise claim and the free speech claim. But just assumed, I think, everybody, that you could address any issue you wanted to, but it's a interlocutory injunction appeal.
That's correct, Your Honor. I think because of the procedural posture of this case, Ms. Polk's burden here is harder than it would be if she were appealing on the motion to dismiss. I'm happy to address either claim first, but starting with the free speech claim, a teacher's interactions with her students and their parents involves only speech made pursuant to her official
Let me ask
duty.
you something with respect to Garcetti. If it's a curriculum matter, you have a stronger case for the application of Garcetti. But how can this be seen as a curricular matter? I mean, it seems to me if you were going to be teaching a physics class and you started talking about the nation's history of systemic racism or something, that when something goes off track or you tell people how to actually teach physics, that's a curriculum matter. But how is this a curriculum matter? Because if it's not a curriculum matter, then the applicability of Garcetti is less clear.
Your Honor, I'd say two responses to that. First of all, teachers do more than teach curriculum. I think if we're talking about what a teacher's responsibilities are in the classroom, that certainly intends to teaching particular subject matter. It also extends to classroom management.
You mean it's a curriculum matter simply because it's in the classroom?
I don't think we have to go that broad, but we can look to this court's decisions in Boring and in Lee, which discussed the breadth of what curricular speech is. And in those cases, this court said that curricular speech included any speech in the classroom that was intended to convey some sort of message. I think certainly on the preferred pronoun side of this policy, Ms. Polk believes that she's being required to convey some sort of message. The court's decision in Lee talked about how bulletin board materials covering religious topics was in fact intended by the teacher to convey some sort of message, and as a result, the school could control that speech.
But let's suppose you're able to move past Garcetti and that we're in a Pickering balance kind of situation. I understand what the state interest is in this situation. When we're talking about transgender status, we're talking about a constellation of very sensitive matters. I think we would all agree, however we feel about those issues, that when we're talking about participation in sports, and we're talking about bathroom issues, and we're talking about treatment of minors and counseling and everything, they are hugely controversial issues about which people of good faith and the like may legitimately have different views. I know people that have one view think maybe the other view is not in good faith, and vice versa, but I'm willing to, perhaps we can agree that these are, that people take positions on these issues that reflect genuine, decent values on both sides of the equation. And I wonder in a matter on which the public is so deeply divided, whether it is appropriate for the state to require MS Polk to convey through pronoun usage or lack thereof its preferred message on transgenderism. I wonder if this isn't a matter, if this can be seen as a matter of compelled speech on very sensitive topics. When you're talking about compelled speech, you are raising all kinds of red flags under the First Amendment. So address the question of whether this is not compelled speech on a very sensitive issue and why they're not requiring MS Polk through the use of certain pronouns to convey the state's desired message.
Your Honor, we don't believe whether this is compelled speech or not has any import in this discussion. Teachers in the public schools are required to provide certain messages to students all the time, sometimes messages they disagree with. There are decades of cases of teachers asking not to be required to teach evolution in school, for example, but courts have unanimously said the school board gets to decide what's taught in the classroom, what messages are provided to students in the classroom, and as a result, there's no First Amendment right attaching here at all. There's simply just no distinction that makes sense in the workforce, in the classroom, about what is compelled speech or not.
Why isn't her request to just use the students' names, even if they are not, even if it's Robert when the person is biologically born female? What is the response to that? Why isn't that sufficient?
Well, Ms. Polk says in her briefs that, this is a neutral solution that everyone should be able to get behind, but that's not actually what her declaration said. She said she would use nicknames for everyone, but she would not use pronouns for transgender and gender nonconforming students.
So not everyone would be treated equally under her proposed accommodation?
That's correct. Her proposed accommodation would be treating students differently. That's at odds with
Why wouldn't the proposed accommodation work? Because you can refer to someone by their last names, which doesn't move one way or another with respect to these sorts of issues. I know that a lot of teachers, when I misbehaved in class, which was more frequent than my parents wished, we would refer to me and say, Wilkinson, just snap out of it, or Wilkinson, go sit in the corner, or whatever. And they would always refer to me by my last name. And so I'm wondering, that seemed to me a reasonable sort of alternative that Ms. Polk has suggested. And why wouldn't that make everybody happy?
Well, Your Honor, Ms. Polk has not suggested that accommodation. That accommodation has come up in some other cases, but all Ms. Polk has asked for below here was to be able to use preferred names and then to not use pronouns. The school board believes that is treating students differently based on their transgender status. But in any event, we don't believe this question of whether the accommodation was reasonable is actually an issue here at all.
Because it would highlight, perhaps highlight transgender students to everyone else as being different from everyone else in the classroom in the way the teacher is treating them.
That's correct, Your Honor. But in any event, the question of whether the accommodation would be reasonable is only at issue with respect to Ms. Polk's Title VII claim. That claim is proceeding before the district court. At issue here is whether the school board has the ability to control the speech that's happening in the classroom as part of Ms. Polk's job duties, and that's all that's at issue here. There is no First Amendment right attaching to this speech, and the school board is well within their rights to
So
control.
where's the limiting principle that you have? I mean, is the school board free without limits to put words into a teacher's mouth just because this is secondary education rather than higher education? And admittedly, in a secondary setting, the school board has a greater latitude. I understand that. But are there no limits at all to the ability of the school board to put words in a teacher's mouth?
Your Honor, I think this goes to Ms. Polk's argument resting on Janus. She refers repeatedly to the sentence in Janus talking about how an employer may insist that the employee deliver any lawful message. That part of Janus is citing to Garcetti, and what Garcetti tells us is that there are many other sources of law that could protect this government employee in the instance. There are whistleblower laws, there are codes of professional conduct, there are other sources of law that could defer an employer from making an employee say something unlawful or wrongful. But Garcetti then is clear. The First Amendment is not the protection in this case. Garcetti says we reject the notion that the First Amendment shields from discipline the expressions employees make pursuant to their
If it's non-curricular, wouldn't the First Amendment provide some protection?
Again, Your Honor, I believe
If it's not a curriculum matter, isn't the individual interest stronger?
again, the role especially of elementary and secondary school teachers goes beyond just teaching the curriculum. It also deals with classroom management. It deals with many other tasks that happen in the classroom.
And doesn't Garcetti address what teachers are doing pursuant to their official duties and interacting with the students in whatever capacity in the classroom? They're only in that classroom pursuant to their official duties, correct?
That's correct, Your Honor, and Garcetti is a very good example here. Garcetti was a teacher, and the issue there was the teacher was writing a letter expressing their own opinions about school budgeting issues. The court said, you know, look, they may have learned things about these school budgeting issues based on their role, but they're engaging in the public discourse. That discussion is outside the scope of their official duties.
Well, there may be administrative duties, and there may be, that may be covered by Garcetti, but a lot of those administrative duties that you are alluding to do not relate to an issue of such volatility on which people of good faith can take different views. This is not simply any old issue. It's not a matter of administrative duties or whether you put the crowns in one cabinet or another, or how you arrange the students' seating or what have you. I mean, I take your point that there are administrative duties that the state requires maybe all the time, but on the other hand, there are lots of free speech claims that fall well below a much less much less strong than this one is.
Your Honor, my response to that would be that contentious issues come up in school classrooms all the time. That's why this court in Lee and in Boring has said we allow the school district to decide what the content of those communications may be. You know, public school education is often compulsory. We don't want to subject students to the idiosyncratic views of individual teachers. There has to be some sort of backstop. That backstop is a democratically elected school board, and that school board gets to decide what kind of messages are communicated in classrooms. There are plenty of cases where a teacher said a stray comment about how they were against the war, or some other contentious issue in public life, and courts have always said the school is fine to just say teachers shouldn't be expressing their own private opinions on these kinds of issues. That's just a decision for the school board.
Now, opposing counsel argued that Mahmoud supports appellant's position for a number of reasons he went over. Do you have a response to that?
Sure. On the free exercise claim in particular, Mahmoud says in most circumstances, Smith applies. That is the case here. Smith applies. This is neutral and generally applicable, especially on a preliminary injunction standard. Ms. Polk didn't put in any evidence suggesting that this was not neutral and generally applicable.
Suppose the school board passed a law maybe in a class on the history of racism in America. Could the school boards, a teacher wants to say, well, segregation is a good idea, and the school board understandably finds that appalling. Does the school board have power to say that, for example, a teacher must say, let's put it a different way, a teacher must say, affirmative action is a great idea, or I hate affirmative action. Can the school board say what the teacher is to say on those issues?
Yes, I think courts have been almost unanimous in saying that school boards can control what content is being taught, and they can also say teachers shouldn't be sharing their own personal views on these particular topics, especially in the elementary and secondary school context. I'm not aware of any courts that have said otherwise. There are clearly different issues at issue in the college-university context. I think courts have said that.
How can you teach the course how can you teach a course on affirmative action without conveying that it's either a good or a bad idea?
Well, I think you could present whatever the curricular material is on that matter. You could engage in a classroom debate on that matter, but you would as a teacher, you could simply not share your own views of that matter.
Can a school board say to a teacher, you are required to say that affirmative action is a good idea or affirmative action is a terrible idea? Could a school board actually require that a teacher at the end of the class say affirmative action is an abhorrent idea or affirmative action is a wonderful idea?
I think it would be a more difficult question if the school board was asking the teacher to affirm their own personal beliefs, but not about just teaching.
Why is that any different from this case?
The school board is not requiring Ms. Polk to say anything about her own beliefs in the classroom. It's simply requiring her to use students' preferred pronouns, and it's simply requiring her to keep student gender identity content.
I'm just concerned about how far the school board, we all find segregation abhorrent, that racial integration is necessary to the welfare of this country, and that's, I think, a general view. But there are other issues like affirmative action where they're just very different views. And if we have these issues, and I would say affirmative action is one, and transgender status, and the constellation of issues around it are another, does a school board just have unfettered power to put words of a specific kind in the mouth of the school teacher and require the school teacher to mouth those words?
Your Honor, I think the school board does have a lot of power in saying what is taught.
No, but I'm telling you, I'm asking you specifically, does the school board have the power to say to a teacher that a teacher must say affirmative action is an abhorrent idea or affirmative action is a very desirable idea?
I don't think the school board could require a teacher to affirm their own beliefs in those things, but I think they could require them to provide a particular message as to a particular topic. Again, that's not the issue here. Ms. Polk is not being required to say anything about
You say it's not the issue here. Why isn't it the issue here? The issue here that we're talking about is compelled speech in the classroom on issues of high public interest in a democracy, and an issue in which people of good faith take different views. What's the difference?
Your Honor, the school board is not requiring Ms. Polk to say that she agrees with this policy, that she thinks that transgender students' preferred pronouns should be used. She's free to say whatever she wants in her letters to the editor or any other context outside of the classroom. The school is only asking that she treat all of her students according to the guidelines, and that is within the school's prerogative, and it's in the school's interest.
If you refer to everybody by their last name, isn't that treating all students equally?
But that is, again, not what Ms. Polk has asked for in this
You
case.
just call them by their last name. That's, everybody's being treated equally.
That may be an accommodation she could have requested. It is not the accommodation she requested in this case.
We're talking about a fairly small minority of teachers that would raise this sort of concern. I would imagine that most teachers would go would find the Montgomery law perfectly congenial. And if we're only talking about a very small number of people, does that weaken the state's interest? You can have, in most cases, will be a situation of teachers will want to comply.
Your Honor, that might tie into the Title VII analysis that the district court will have to do in the first instance as of what kind of accommodations the schools could or should offer to their teachers, but that's not an issue here. The issue here is whether this is speech pursuant to Ms. Polk's official duties. It's whether these policies are neutral and generally applicable, and Garcetti and Employment Division v. Smith tells us there's no protection for Ms. Polk's speech.
Is it relevant here that this is a substitute teacher bringing the suit?
It's very relevant here that this is a substitute teacher. There are certainly interests that the school district has with respect to all of its teachers, but it certainly has an interest in saying that, you know, Ms. Polk should not be the one that's having these difficult conversations with parents. Ms. Polk should not be the one who is deciding how to call students in a particular way if she's only coming into the classroom for one day. Ms. Polk was a substitute teacher in the Montgomery County Public Schools for 10 days in 8 different schools. The school has many interests, but it certainly has an interest in channeling difficult conversations to people who have more context, to administrators, and to ensuring continuity for the students. So that would certainly be one way to address this case. Ms. Polk is a substitute teacher. This is a special case, and she should not be able to insert herself into difficult conversations based on one day of knowledge of a student.
Is it relevant here that they're seeking a mandatory injunction rather than a prohibitive injunction?
We think the school board should win under both standards, but it is relevant here. Ms. Polk,
Well, with a mandatory injunction, there's a greater burden,
that's correct.
substantially greater burden. We got a recent case on that.
That's correct. And Ms. Polk, the sort of status quo ex ante we're looking at is the summer before she was teaching, she was required to complete training and affirm her compliance with the guidelines. She didn't do so. That was the status quo, and that's what she's trying to upset. So yes.
Well, Judge King makes a very interesting point. Why wouldn't this be a mandatory injunction? We're requiring you to use certain pronouns. That seems pretty mandatory to me.
Well, Your Honor, I think the question is whether the status quo as it existed, if she's trying to go, which status quo is she trying to go back to? And I think the position that Ms. Polk was in before she brought the case was that she was prohibited from teaching because she wasn't going to complete the training, affirm compliance with the guidelines. So she's asking that the school board change its policies from that point and allow her to continue teaching.
Judge Thacker, do you have questions? Judge King?
I'm good.
Thank you.
Thank you very much. You have some rebuttal time, Mr. Claybrook.
Thank you, Your Honor. And no, Ms. Polk is not mandating that, trying to get a mandate that the school district did anything. She's trying to get it to prohibit the school district from taking action against her. Now, let me address the Garcetti point. Garcetti says, of course, that not all speech within the office is automatically exposed to restriction by the government employer, and that the speech to be government speech that the government may control, it must be speech that the employer itself has.
Well, there's some circuits that have taken the view that Garcetti doesn't apply, where you're talking about non-curricular matters.
Right, Garcetti does not apply to non-curricular matters, Your Honor. That's one of the.
There's some circuits that have said, I think we may have hinted in that direction, that Garcetti does not apply where we're talking about non-curricular speech or non-curricular matters. And then the response I got was, well, these are just administrative matters that school boards require of teachers all the time, like when they adjourn class, or what the seating arrangement is, or what have you. But that, of course, differs in kind from what's being done here.
Of course, this is much more like Barnett, and administrative matter of having to say the Pledge of Allegiance in the morning, which they found to be compelled speech and unconstitutional, of course. So the question becomes, all right, does the employer itself commission or create the speech that we're talking about here? Does this speech owe its existence to the government employment, which is another way Garcetti expresses it? You know, when I was born, I got a name. My parents gave me that name, not the school. The school didn't commission it. They gave me a nickname. The school didn't create that nickname. My parents did. When I was born, I had a sex.
So what if the parents of a particular child came to the school, to the teacher, and asked that the teacher refer to their child by particular pronouns?
That would still violate Ms. Polk's religious convictions. She would
So-
refer to them by the name that the parents asked.
She would refer to the pronouns that the parents asked?
To the name.
Well, the parents are asking that the child be treated with respect and be referred to by the pronouns that the parents and the child prefer, but she wouldn't do that?
She wouldn't do it with the pronouns, Your Honor. She would with the name.
I'm just wondering where the limiting principle is on this. How far can discrimination go in the name of religion?
Well, we don't see any discrimination here at all, Your Honor.
Well, this would be treating particular children in the classroom different than others, even based on what appellant said she would do. She would refer to the transgender children by their names, but would use pronouns with everybody else. So that's treating them unequally. So how far can you go in treating students unequally in the name of religion? I could see this slippery slope toward, well, there's a Muslim student in the class that might offend a Christian teacher's religion, or even using religion to discriminate or treat unequally people of different races.
No, we think the line that she's drawn is very easy to administer.
That's the line that you're seeking to draw here, but I'm just concerned about the slippery slope of using religion as a method of treating people unequally.
It's the line that her religious beliefs draw, Your Honor. And,
I know, that's my point.
yeah.
With the, aren't there instances where, with respect to compelled speech, the school board would have authority, if they so chose, to tell a teacher what to say? Let's suppose a school board took a view that I think we all hold, that this is a course on racial history and everything, and the school board said, we want you to convey something which all of us, I certainly hold it, I think most people hold it throughout society, that racial segregation is abhorrent. And couldn't a school board say to the teacher, we want you to convey the message in the interest of fairness and in the interest of equal treatment of all of our students of whatever race or ethnicity. We want you to say, let there be no doubt that racial segregation and racial discrimination and ethnic discrimination is abhorrent. And a school board says, we want the teacher to convey that message and we want it stated explicitly so that there will be no doubt where this school board and where this class and what this entire school system stands for. That's maybe controversial, but it's something that 99% of the people, I think, and a huge number of people in our country believe that discrimination of any kind and segregation is an abhorrent practice, and we want the individual teacher to convey that message. Couldn't the school board do that?
As part of the curriculum, they certainly could, Your Honor.
But what if
That's
the
not-
teacher said it was against their religion for some reason?
Well, race has a special place. We have a 14th Amendment that handles that, Your Honor. So if it's part of the curriculum of the school, they can do it.
But what I'm saying is, doesn't the school board have to have some degree of control?
Of course, they have to have some degree of control.
The school board needs to run the school.
Well, they set the curriculum, they decide what it is, but this speech that we're talking about here does not owe its existence to the curriculum or to the school board. And I want to make clear that Ms. Polk is not
So
trying
you think the example I gave was curriculum related and this is not curriculum related?
That's how I understood your question, Your Honor, yes. Ms. Polk
You're
is
saying
not-
yes to which part of that?
that
It is
One was-
curriculum related?
as he described it, that's why I understood his question. His question was talking about curricular related, that would be part of the curriculum to talk about
That racial discrimination is
about racial
abhorrent?
discrimination is abhorrent.
Well,
But this is not part of the
Let's
curriculum.
suppose that message was going to be conveyed in a physics class, that the school board says this is a message we want conveyed throughout the school system, in physics class as well as in other classes. And we just want you to say, look, this is the kind of school system we run. It's one in which discrimination will not be tolerated, and racial segregation is absolutely abhorrent.
You're getting to it.
And we want that conveyed explicitly in every classroom, whether it's related to the subject under discussion or not.
You can put it up on the wall in every classroom, perhaps. That would be permissible.
So no,
Just-
it's not enough to just put it on the wall. You have to
Well,
say it.
if the teacher had a religious objection, which I'm aware of no religious objection to that, but if there were a religious objection and you're talking about the physics class and that's the only class this is talking about, then we'd have a closer case.
I think one of the ways we may differ, and I think Judge Thacker's good questions have been probing the point, is I'm not sure I see this as a religious matter. There are many secular issues that have a religious component and that have, that people may have religious views about it, but that doesn't detract from what's overall their secular character. People may have a religious view about one thing or another. I can think of an infinite number of things that religion may touch upon, but that doesn't remove them entirely from the secular sphere, does it?
Yes, and the opposite's also true. Just because it has some secular manifestations does not remove it from the religious sphere.
But I
And in
just
this
said,
case,
I don't see that we can say, oh, well, this is religious in part, this ends the matter. That it's.
For Ms. Polk, it is religious, and it goes against her religious, sincerely held beliefs. Now, the point I want to make in closing is that she's not trying to say that these gender identity guidelines have to be thrown out the window. The school board has adopted them, so they are the school's guidelines and policy about this, but she thinks they cannot be constitutionally applied to her in certain respects to which she objects, using the pronouns which do not accord to the biological sex of the child, and keeping quiet from parents what is happening at school with their children. Thank you, Your Honors.
Bob, you have any further? Stephanie, do you have any? All right, we want to thank you both, and we'd like to come down and greet you, and then we'll move directly into our next case. All right, you want to take a brief recess? All right. All of us would like to have a brief recess after, if we may.
This honorable court will take a brief recess.
be seated. All right, Mr. McLeary?
Kenneth McClay on behalf of Robert Conley.
I think you need to speak up, probably. I mean, if I need you to, I'm sure everybody else does.
Thank you very much, Judge Thacker. My name is Kenneth McClay. I'm representing Robert Conley. It's an honor for me to be here before this court. Thank you for taking the time to take a look at this. Unfortunately, I really didn't want to be here, or I didn't want to be in the district court either. And within a couple of weeks after filing the complaint, I filed a motion to voluntarily dismiss because the defendant had not filed an answer. The defendant had not filed a motion for summary judgment, and therefore I had an absolute right to remove the case. And I had a pretty good reason for getting it out.
You filed a motion
Well, I did, Your Honor.
to dismiss, but you didn't call it a notice.
Well, unfortunately, two things.
The
One,
rule calls it a notice.
correct. And the problem is, being of our generation, I look at these guys with their computers, and they can hit buttons and make Pacer work magic. I look at them, and I'm confused. I'm from the old day where I walked over to the clerk's office, and I handed them a motion or a pleading, and I had a very knowledgeable clerk.
No, I mean, I don't understand why you didn't file the motion. It seems my colleague, Judge King, is absolutely right about this. The rule could not be clearer. The Rule 41A says, you know, if you want the automatic dismissal, file the motion. Otherwise, it's a discretionary matter with the district court.
I did file the motion. What he's saying is that I filed a motion to dismiss under Maryland Rule 41A and asked for a voluntary dismissal without prejudice.
I think what you needed to file was a notice of dismissal.
And I
It's
understand,
self-executing.
and I'm not sure that the computer system Pacer, when we struggled through the computers, whether they acknowledged it, or a notice, a line, you know, back in the day, we filed a thing called a line with the court.
It had to be before there was an answer or a motion for summary judgment.
And that was done. And in fact,
There had been no answer?
there's still no answer.
There had
And
been no summary judgment?
That's correct.
Or no motion for summary judgment?
That's correct, and there's still not.
But-
And I could still file it, but now that there is a,
And if you filed if that's construed as a motion for dismissal, a 41, in effect, a 41A1 notice of dismissal, it's self-executing.
it should have been, and I can't understand why the clerk's
And if
office
it's
didn't.
self-executing, there's nothing that the court could do
That's-
about it.
that's correct.
Or deal with it later.
That's my
But
point.
if you don't file the motion, it's not self-executing.
I did file the motion. I filed it on April 30th, 2024, less than 6 weeks after I filed the complaint. And no answer had been filed, and no motion for summary judgment had been filed, and it should have resolved this matter entirely. Everything that's happened after April 30th of 2024 is advisory and should be vacated. That's absolutely correct, and Your Honor.
Your argument is it's the substance of what you filed versus the form that matters, particularly
Correct.
where this is self-executing.
Absolutely. Absolutely, and it's frustrating, like I said, some clerks say it must say the word line, or it must say notice.
You know, even if we construe it the way you want us to construe it, you're liable to end up back in federal court. After it goes back, they might remove it.
No, they can't. And here's the bottom line. It's already been filed in the state court. It's already proceeding in the state court. Motions and answers have already been extended. Some settlement offers have been done.
I thought you filed this case initially in federal court.
I did. And
Well,
then,
then why, you filed it, aren't you jerking the system around?
no, Your Honor.
Well, excuse me, you filed initially your suit in federal court. And now you're trying to get out of federal court.
For a good reason, Your Honor.
What was the reason? You didn't like the judge?
No, Your Honor.
No, that's the question I have. People file something And you may have a change of heart because they didn't like the judge to whom he was assigned.
All right, in this case, the judge had not been assigned at the time that I filed the
Well,
motion.
there's something else, I'm saying there's something else.
I can't wait to
These
tell you what
changes-
it is.
These changes of heart.
I can't tell you what it is. I can't. Please. It is 3 weeks later, on March 24th of 2024, the Supreme Court of the State of Maryland took cert in a case that had the same exclusive remedies arguments. And it dawned on me that this case should proceed up through the Maryland Appellate Courts as a Maryland issue of Labor and Employment Article Section 9-509, which is, not only did that case then make its way through the appellate court, but this last July, the court, in a very split decision, 4-3, which is unusual for the Maryland Supreme Court to be so split on decisions, with many dissenting opinions, and a lot of activity at the legislature coming up this fall to address this code section. Seeing that coming down the pike, now I didn't know it on March 11th when I filed the suit. On March 11th when I filed the suit, I had a client from West Virginia who felt that he would get a fairer shake in the federal court system than he would in Allegheny County, Maryland. And it wasn't until 3 weeks later, on March 24th, when I saw that cert had been granted on a matter that I didn't even know was in existence, and it was very similar to this, I then cited that case and said, Judge, in light of this appellate case that's pending at the Supreme Court of Maryland, it would be appropriate for us to dismiss this case, 41A, voluntary dismissal without prejudice. We also then refiled in Allegheny County. And when I filed the motion...
Allegheny County, what, Cumberland?
Yes, that's correct. And
That's
so-
where you're litigating in Cumberland.
that's correct. That's correct. And that,
Where then you got, your client is
injured.
injured, very
There.
badly injured.
Yes, he was.
He fell through a ceiling
Yes, he did.
20 feet on a concrete pad or something.
Correct. Horrible. And it was an injury that was preventable, that was precipitated by a general contractor.
What do you call what you admit that you made a mistake? Is that right? Is it a misnomer or a clerical error?
I'm not sure, I don't know how to work computers well enough to know what the difference is between hitting a button that says notice or motion. All I know is that the substance was, I cite the Maryland rule, or the federal rule, 41A. I
You
cite
cited the right rule,
and I cite the basis.
but you misnamed it.
I called it
think-
a motion instead of a,
You called it
Instead
a
of a
motion
notice.
instead of a notice of
But-
dismissal.
But you cited the rule, and the rule itself
Yeah.
says that it's self-executing.
thank
That
you.
rule lets you do it ex parte.
Correct.
I mean, the plaintiff can file a notice of dismissal before there's been an answer.
That's correct.
Or a motion for summary judgment,
And that's what I did.
41A1.
And that's what I did. And I didn't
You
do it
didn't-
because, and the judge hadn't even been
But to
selected yet.
just get the benefit of it, you had to call it right. So the question
Okay.
is whether we're going to hold you to the language of the rule or whether we're going to construe what you did as substantial compliance or something.
Thank you. And that is what I'm asking. And I'm very, Judge Wilkerson, I'm very cognizant of judge shopping. And that is not a case that happened here because I don't believe the judge had ever even been assigned yet at the time that we filed that. I certainly have not enough experience in the federal court to tell you that I know the difference between these.
Are you a
these
Cumberland
benches.
lawyer?
No, Your Honor, I was a Maryland Workers' Compensation Commissioner appointed by
Oh, okay.
Governor Ehrlich for 10 years. I spent 15 years doing insurance defense work, workers' comp, roadway trucking company, and then I've spent the last 10 years doing plaintiff's work out of Annapolis. But I do practice in Cumberland, and I love the western part of that state.
And your plaintiff is from, you said West Virginia?
He's from Martinsburg, West Virginia.
Martinsburg.
Correct. And if I get a chance to get to the Greenbrier, I do it every time I can because you got a beautiful state out there. So that is the substance of why I'm here, is this
Well, I mean, part of why you're here is that the ultimate resolution of your case was a dismissal
Well, that's true.
of the claim. And it indicated that Daystar, both the general contractor and the subcontractor, were covered by the Workers' Compensation
That's,
Act.
That's correct.
And that isn't the result you wanted. You did not want to face, you did not want the defendant to be able to claim protection of the Workers' Compensation Act. And that's a big reason that case is here. It's not just a jurisdictional dispute, it's the fact that you didn't like the bottom line, which is that the defendant here in the district court were trying to defend the Workers' Compensation Act, because it's a whole thing. To have a good workers' compensation program, you have to have universal buy-in. And you're trying to weaken it, and the Daystar and the district court are trying to defend it. And that's a big reason that we're here. Let's remember, you're talking about this jurisdictional issue and everything, but the point is you didn't like the ultimate result.
Judge, I believe that the ultimate result is incorrect because I do not believe that, listen, the workers' compensation system is near to my heart. I was a judge on the Workers' Comp Commission for 10 years. I love the system and I know it, and I bring the book with me. I don't believe that when the primary employer, the direct employer, has workers' comp coverage and they pay up to their obligations, that then other bad actors on a job site that are negligent and cause injury to people should be able to walk away from it.
I hear you, but they're all involved in the same project. The general contractor and the subcontractor were working on the same project, which was renovation of the building. And the district court said, when they're working on the same project, there's no reason to sever them. And the whole one, well, what's wrong with the district court's resolution of that?
Because they extend the cloak of immunity to parties that were negligent, that were not the direct employer. Workers' comp is about a relationship between a direct employer and their
But we don't have to
employees.
decide any of that stuff. In this case, all we hear on is whether you can get the benefit of Rule 41, A1, and
In a
B.
Correct, in a self-executing manner.
A says without a court order.
Correct.
A notice of dismissal before the opposing party serves either an answer or a motion for summary judgment.
Correct.
And then B says effect, unless the notice or stipulation states otherwise, the dismissal is without prejudice.
Correct.
And that's what you were trying to get the benefit of, but you didn't call it the right thing. You misnamed it.
I cited it and the reason. And
Is it substantial compliance or what?
that is substantial compliance.
Is that what you're trying to get us to do?
Yes, Your Honor, and vacate what's happened in the district court so that the circuit court for Allegheny County can continue what it's done to date, which is to litigate these issues between these various parties. Some get a cloak of immunity, some do not with regards to my client's injuries. And I do not believe that what happened in the district court of the federal district court.
So these workers' compensation issues you're talking about need to be addressed
That's correct.
in the circuit court of Allegheny County.
That's correct.
And they're state law issues.
That's correct. And that's exactly what we're here for. So, Your Honor.
Next time you need to read the rule, I would think.
Well, it's not, Your Honor, it's working this computer system, this PACER system. If you don't hit the right button, or if you don't turn it, it'll kick it back or vacate it, and you can see that the docket entries are replete with errors or kickbacks from the PACER. And I appreciate these guys over here with the computers. These young kids know what they're doing. I just have reached a point in my life where I miss dearly the ability to walk to the clerk's office and hand a notice to the clerk or hand a pleading to the clerk and have it executed and date stamped and brought back, and you know what happened and the communication is there. There's no communication with your PACER system. I love it, the efficiency, and I love the fact that my young kids know this stuff, but obviously we did not hit the notice button, we hit the motion button, but we cited it wouldn't have changed the entire process, and if it's self-executing as a motion, it should as a notice as well. So with all due respect.
Is the motion you filed itself, is it in the JA somewhere?
What's a JA? Joint appendix?
The joint appendix. Yeah, this.
You know,
I was
I don't
just
think it's in
looking
there.
for, yeah, I was just
It's
looking
in the
for
thing.
it. That would
I think
make it easier
It's in the
to.
record, number 21.
Right, right. It's not listed as being in here.
all right, I'm sorry, it was filed on April 30th, it's listed as
Right.
21,
Yeah, I see the docket sheet.
yeah, 21.
And I do see the multiple kickbacks in the docket sheet
Right.
as well.
So, thank you. I'm reserving my 12 seconds.
Thank you. We'll be pleased to hear from Ms. Casey.
Good morning, Your Honors. Lindsay Casey on behalf of Daystar Builders Incorporated. It is unfortunate that the motion to dismiss without prejudice is not part of the joint appendix. Actually, when the appellants filed their opening brief, this argument regarding notice of dismissal, to my memory, was not part of the initial brief. And then a corrected brief was filed later, after the joint appendix was filed, that included this argument. And that may be why the motion for dismissal without prejudice was not filed, or part of the joint appendix. It was entitled as a motion, not a notice of dismissal.
But it cited the correct rule.
I don't believe so. I don't believe it did. And I apologize
What
that
do
we're not prepared.
you also don't have it in front of you?
I don't have it printed out.
Even
I could,
I think it did. So the question is whether we're going to accept the motion as a notice of dismissal.
well, I will also say something.
You acknowledge that if we accept that, there not been an answer filed, there not been a motion for summary judgment, and and a notice of dismissal under those circumstances is self-executing.
Yeah, yes,
The
Your-
effect is, the dismissal is effective immediately and it's without prejudice. And if anything happened after that, it would be what we used to call held for naught at the end of it.
yes, I understand the effect
Yeah.
that it would have
The
on
only
the,
question that I see it, and I've plowed a few of these furrows over the years, is whether the motion for dismissal is going to be deemed a notice of dismissal under Rule 41A1. In which case, the effect of it is, it was self-executing and a dismissal without prejudice.
one other argument I would make about that, Your Honor, is this issue was not raised.
It wasn't
in the district
raised,
court.
it wasn't raised before the district court. That's right. If it
Yes.
been raised before the district court, it had been treated this way.
Right, yes, so it was not raised, and this is the
Well,
first time it has.
But isn't it a jurisdictional question?
It is.
If it was self-executing, then was no jurisdiction at that moment in the district court.
That's what I meant when I
Can you
said
waive
held for
jurisdiction?
naught.
Yeah. Can you waive jurisdictional issues?
Yes, I would agree that if plaintiff had, or appellants had filed a notice of dismissal, the case would have been dismissed without prejudice. But that is not what happened here. He filed a motion for dismissal without prejudice, and there is a case that I included in unreported opinion.
And I think you said you don't think that it cited the correct rule?
I don't believe, I would say I'm 80% sure, and I apologize for not being prepared.
I thought it did.
It's not to my
But-
memory. But
It's docket number 21.
I could look it up on, my laptop. But, you know, to address some other things, there is a difference between a motion for dismissal without prejudice and a notice of dismissal without prejudice, because there's the two dismissal rule. So if you file a notice of dismissal two times, a notice of dismissal without prejudice 2 times, you are then out of luck. You cannot file another notice of dismissal without prejudice that becomes with prejudice. So there is a reason why a plaintiff may choose to file a motion of dismissal without prejudice versus a notice of
We're
dismissal.
dealing here with a plaintiff who's severely injured. Now, his claims may be meritless, I don't know what the claims are, but we do know that he was severely injured. Correct?
Yes, Your Honor. We haven't done any discovery, but yes, I would agree.
And we do know that the state court in Allegheny County is proceeding with the case.
Well, Your Honor, I filed the same motion, a motion to dismiss with prejudice in the state court on the same basis, the statutory employer defense, and the court granted my motion to dismiss with prejudice.
So you're out of the case?
I'm sorry, Your Honor?
You're out of the case?
Yes. Well,
Okay.
there is another defendant in Allegheny County is another defendant in that case, so the judgment is not final, so I don't know what will occur in the future. But yes, the court did grant the Allegheny County court did.
But none of that's in this record.
No, it's not. That happened after.
Both lawyers have been talking about a lot of things that aren't in the record.
Yes, Your Honor.
And the
that-
record doesn't even include this
What we need to see.
motion or notice. I mean,
Yes.
not the record. The record does include it, document 21, or whatever it's called, but neither of you put it in the appendix.
Yes, Your Honor, that's correct.
And it was misnamed when it was filed.
Well, I don't believe it was misnamed. I believe that that the appellants wanted to intended to file a motion to dismiss without prejudice because of the diversity jurisdiction issue which they created when they added Erie Insurance as a defendant. I think it was purposeful. I think it was intentional. They wanted the court to determine that there was no longer diversity jurisdiction, and that's why it was a motion and not a notice of dismissal. I believe that the appellants wanted the court to decide that issue when determining whether the case should be dismissed without prejudice. So I don't believe a notice of dismissal was the intention when that motion for dismissal without prejudice was filed.
Well, I do have a cut. Is this it's docket entry number 21, that was filed April 30th? And I don't see the rule cited in here. It says pursuant to Federal Rule 28, United States Code Section 1332, respectfully request dismissal. And it is pursuant to, it talks about diversity. That diversity jurisdiction no longer exists between the parties.
Yes, thank you, Your Honor. The Ledford case that appellants argue was the reason that they wanted the case dismissed without prejudice, the Supreme Court case, is not similar to this case. In that case, it was whether an adult dependent daughter could file a claim in court against a principal contractor. And the issue was whether an adult dependent was considered a dependent for the workers' compensation laws or not. And if not, she could file in court.
What effect would an affirmance in this case, an affirmance of the dismissal, have upon the state court proceedings?
It doesn't, Your Honor. I was just addressing the appellant's counsel was using Ledford as the reason why he filed the dismissal in federal court, is because this Ledford case was, the Supreme Court of Maryland granted.
But I'm just saying, just assuming arguendo, that we thought the district court was correct in dismissing the case on the merits. What effect does that have on the proceedings that are going on in Maryland?
In the state court, Your Honor?
Yeah, in the state court.
I believe then the appellants wouldn't have any right to appeal the dismissal of my client with prejudice by the state court, because if the federal court judgment is final, then the state court action should never have been brought.
The state court action, what?
Because basically what, you know, the appellants filed the federal court action and then also filed a state court action on the same basis. And I did, as part of my motion to dismiss with prejudice, I cited the first to file rule and how this was already pending in federal court, and you can't file suit in both federal and state court for the same claims.
Okay, so on the jurisdictional issue, your view of it is that there's clearly complete diversity here, because everything points to Erie being a Pennsylvania citizen.
Yes, Your Honor. Their principal place of business is in Pennsylvania, incorporated in Pennsylvania, and there was no,
And you've got Daystar is Maryland, and then Connolly is West Virginia, and so you'd have complete diversity.
yes, Your Honor.
And what you're saying is that they've initially filed in federal court, now they've had a change of heart, and there's a fraudulent joinder here in order to destroy diversity, and that there was no good reason to have Erie Railroad in the case except to destroy complete diversity. Except to destroy diversity jurisdiction. And that the evidence here all pointed to the fact that there was no evidence here that Erie was a citizen of Maryland. That all the evidence here pointed to the fact that it was a Pennsylvania citizen, which would leave complete diversity intact. And so you've got a situation where someone initially files in federal court, then goes over to state court, then tries in federal court to undermine the existence of complete diversity by claiming that Erie Company is somehow a citizen of Maryland when they were incorporated in West Virginia, in Pennsylvania. There's no evidence that they were incorporated in Maryland. The evidence from the Maryland Department of Assessments was that Erie was a foreign corporation, founded and incorporated in Pennsylvania. And what you're saying is, this is a lot of shenanigans. There's a change of heart and a fraudulent joinder, and they shouldn't be allowed to get away with it. That's what you're saying. We should not allow this kind of thing to go on. It's manipulative, and that's your point of view.
Yes, Your Honor. When I researched this issue, I couldn't find something exactly like this, because usually it's a defendant who tries to remove a case to federal court, and then the plaintiff tries to defeat diversity jurisdiction. It doesn't seem...
Did you find the Williams case out of the Fifth Circuit, where the Fifth Circuit said that it mattered not that the plaintiffs failed to cite Rule 41, as there was no question that plaintiffs were acting pursuant to it, and it also didn't matter that their request was styled as a motion for dismissal rather than a notice of a dismissal, because it was a distinction without a difference given the circumstances where there had not been a answer filed yet. Do you know that case?
I do not, Your Honor. Was it...
Because that does seem to be on point here. It's Williams versus Ezel, E-Z-E-L-L, 531 Fed 2nd, 1261. And then we also have a couple unpublished opinions in the Fourth Circuit.
Yes, Your Honor.
that cite to that case.
Yes, Your Honor, I did, like, as I said, I
Our
included.
unpublished decisions actually say that the request for voluntary dismissal filed within the limits of Rule 41A1AI should be construed as a notice of dismissal under that rule, regardless of how it is styled, unquote. Now, those are unpublished opinions of this court that say that.
Yes, sir, but I also have an unpublished opinion that says something, different, and I included that in my,
And which one are you
It's-
directing us to?
Fidelity National Title.
Right, I have that.
Okay,
Thank
yes, and in that one, the court said it was a motion and not a notice of dismissal. And specifically,
Was Fidelity a Fourth Circuit case?
it's a district court, it's a federal district court case.
It's the District of
Yes,
Maryland. Yes,
yes.
Judge King was talking about Fourth Circuit cases.
I'm talking about the
which-
Fourth Circuit. I'm talking about this court.
Yes,
What
Your
we
Honor.
said. You're citing us a District of Maryland.
Yes, Your Honor.
Yeah. But what I
Would
read
you-
to you is in unpublished Fourth Circuit opinions, a request for voluntary dismissal, filed within the limits of Rule 41A1AI, should be construed as a notice of dismissal under that rule, regardless of how it is styled, unquote. See Satterfield versus Vaughn, number 246298, Fourth Circuit, August 2024. Citing Williams versus Edsel, which the Fifth Circuit case that Judge Thacker read to you.
Your Honor, one thing I will say is,
And there's another one here, Jackson versus United States, 245 Fed Appendix 258, Fourth Circuit, 2007.
And-
Citing the Williams case of the Fifth Circuit and reciting, quote, the fact that Jackson filed a motion for dismissal rather than a notice of dismissal is not relevant, unquote, as he cited Rule 41A1 in his motion, and the motion was filed prior to any response by the government.
But
And
as-
that's a case of this court, unpublished, which means it's not precedent. And the other one I gave you is also unpublished, but those are decisions made by this court in similar situations.
but as we know, that rule was not cited. The rule was not cited in the motion.
This case here says it wasn't.
No, in all,
Well, this case was cited. In
But it-
that case, it was cited, but here it wasn't
it
cited.
was not cited, so the
That's
court
right.
is left with what rule am I using here? This is a motion, the court wasn't directed to a rule to know how it was supposed to proceed. Perhaps if the rule had been cited, then the court could go to the rule and proceed however it felt it should, based on the interpretation.
What
of the rule.
would opposing counsel, what would be the harm? My colleagues have pointed out that this is a question of state law. And what would be the harm of simply saying that there was substantial compliance and that the dismissal should have been without prejudice and we didn't have jurisdiction to go further, and leaving this up to the state court system to resolve a question essentially of state law, Maryland law? What would be the harm in that disposition to let a state law question be resolved by the most relevant state court on the grounds that we dismissal should have been without prejudice, and we like jurisdiction to go further. I mean, what would be the harm in having the state law question go over to the state courts?
Well, Your Honor, when we briefed these issues, the state court had not dismissed my client. That occurred after. However, as I said before, I believe that if the district court's order stands, then there would be no right of appeal of the state court order dismissing my client with prejudice.
Why don't you want to let the Maryland courts decide this?
For that reason, Your Honor, is that unless the Supreme Court decided to take up this issue, then my client would be, the workers' compensation issue would be decided. My client is concerned with the workers' compensation issue.
Well, the workers' compensation issues are uniquely state law.
I didn't file the case in
We're
federal
not
court.
that much in that business.
Right,
And where did the injury occur again?
in Allegheny County.
In Pennsylvania.
In Maryland.
Oh, I'm sorry, in Maryland.
So, given that the injury occurred in Maryland, given what Judge King has said about workers' comp issues being uniquely ones of state law, what would be the harm in allowing, I mean, I know you don't want that result because you are representing your client's interest, and that's altogether right. But from a structural standpoint, would it be the worst thing in the world to say the dismissal should have been without prejudice, the district court was wrong in dismissing and denying that? There was substantial compliance, it goes over to the state court. That's where the injury occurred, question of state law. That's what the state court should take up. I know it's not good from the standpoint of your client, but overall structurally for the judicial system, is that a bad result?
No, Your Honor, I don't believe it is. I just want to clarify that the appellants also were appealing the decision based on the workers' comp laws that the district court found.
What did you say?
The appellants, it wasn't just the notice of dismissal that was included in the appeal, in the
Well,
notice.
we wouldn't reach any of those if we recognized
There's
Agreed.
no jurisdiction.
the notice of dismissal. We don't have any play in that.
Yes, but if you,
Anything that the district court did, the federal district court did after that notice of dismissal, if it was effective, would be, as I said, in the old terms, held for naught.
yes, Your Honor, I agree. But if you did find that the motion for dismissal was properly denied by the district court, then there would be a determination on whether the district court properly found on the workers' compensation issues, which, yes, admittedly, that is what my clients care about. The state court has dismissed my clients with prejudice in the state court after these briefs were filed.
And your view is that on the merits, that they're all working on the same project, and that there's no reason to, just for workers' compensation purposes, to sever the general contractor and a sub?
Because my client would have had potential exposure to a workers' compensation claim against it by Mr. Connolly, if Mr. Connolly's direct employer hadn't had workers' compensation insurance, my client cannot be sued, Daystar cannot be sued in court. Regardless of whether Daystar actually paid benefits, it's irrelevant. It's the potential liability in workers' comp that is exclusive. You can't have potential liability in workers' comp and potential liability in court.
It's an immunity
Yes,
derived from workers' comp, which you think cuts off the suit here.
yes,
I understand.
and as did the district court and the state court.
Do you have further questions, Bob?
No.
All right, thank you very much.
Thank you, Your Honor.
We have some rebuttal time, sir.
Thank you. This court has framed the issue beautifully, and
No, but I'm still worried about it all. It does seem a little bit shifty to me. When you file in one court, then you go to another court and you try to create incomplete diversity, and I'm not sure that there's any real basis for that, because it seems to me from all the available evidence, including from Maryland, that Erie Railroad was a Pennsylvania resident. So at the end of the day, there seems to me to be diversity jurisdiction on the part of the district court. I'm not anxious to get into the merits, but if there's jurisdiction there, we would have to. And so I'm torn between the appeal of having the state courts resolve an issue of state law on the one hand, and on the other hand, I don't like the joinder here. I don't like introducing Erie Railroad into this case in order to destroy diversity when it is absolutely apparent from the evidence, including the Maryland Department of Assessments, that Erie is a Pennsylvania resident. And the district court didn't like it, and I don't like it. On the other hand, I do understand the argument that state law issue with a place of injury in Maryland, the Maryland courts should be the ones to decide it. But it's not a slam dunk either way for me.
Your Honor, the only reason that Erie Insurance Company was impled is because they are the workers' comp carrier that has paid out $1 million in medical bills to my client, and they were asserting their subrogation rights, and they wanted me to protect their interest as well. Therefore, I entered my appearance on their behalf. In addition to that, I saw the Hertz case from the U.S. Supreme Court that, unfortunately, it was a Ninth Circuit, so I don't read it that well over on this side of the coast, but it did say that multiple states can have citizenship. A corporation that has a significant nerve center, and Judge Niemeyer had written a reported opinion that talked about the nerve center test versus the operational center test. And Erie Insurance Company has such a large presence in Maryland with major claims centers in Hagerstown and in Silver Spring that I said, it appears that you should join, and if you do, it breaks diversity. But that's another reason why I asked on April 30th, 6 weeks after filing the suit, I said, please let us dismiss without prejudice so that we can refile in state court.
Why weren't they in the suit earlier?
Well, because my concern was with the injured worker, Robert Conley. Erie then approached me and said, we have $1 million exposure on this. We get the first money back from this lawsuit. Are you going to protect our interest? And I said, yes, I will. So that's why they weren't in it to begin with. But really, at the end of the day, I wrote that we want to go back to the state court, and the reason we chose to go back there was because the Supreme Court on March 24th took cert of a case that involved exclusive remedies, and that case and that code section resulted in a decision this past July that was highly contentious. It was a 4-3 decision with many dissenting opinions, and it's exactly why I wanted to be in the Maryland Supreme Court on this Labor and Employment Article 9-509 decision. How far does a cloak of immunity go up the ladder at a construction site? Does everybody get immunity if there's a workers' comp, or is it just the company?
Those are state
that
law
pays for it?
issues.
Correct.
There are state law issues.
And-
Judge Thacker gave you a case here.
Yes.
From the Fifth Circuit. Not
Williams.
the circuit.
That's correct. Fifth
That
Circuit
supports your
Williams.
proposition. I gave you 2 unpublished cases
I'd like to amend
from
it.
the Fourth Circuit
Thank you.
that support the proposition. And you didn't cite any of them. I don't think.
That's correct, Your Honor.
Okay.
And I appreciate the insight of particularly the Fifth Circuit, notice of substantial compliance is important. And asking the district court to dismiss it, to let us refile in the state court 6 weeks after filing, I think is substantial compliance with that request.
But if there is substantial compliance
Yes,
under those cases,
yes.
and the notice of dismissal was effective, that was the end of the proceedings in the federal court. And
Correct.
nothing that happened after that
For not.
is worth the paper it's written on. It's over with. It's held for naught. You got it?
Final word. Thank you.
All right, we thank you. We'll come down and re-counsel, and we'll move into our final case. All right, please be seated. Ms. Lewis?
May it please the court. My name is Deanna Maria Lewis, and I represent the appellant in this matter, Ms. Wanda Johnson. This appeal concerns the district court's erroneous dismissal of Ms. Johnson's Title VII claims under the Rule 12b6 stage, despite the well-planned factual allegations which we assert, if taken as true, establish unlawful discrimination, retaliation, and a Monell claim. Accordingly, we respectfully request that this court reverse the dismissal and remand the case back to the district court for discovery and subsequent adjudication on the merits. Pursuant to Ashcroft v. Iqbal, Bell Atlantic Court v. Twombly, and Rule 8 of the Federal Rules of Civil Procedure, in relevant part, a 12b6 motion to dismiss a complaint must contain sufficient factual matter accepted as true to state a claim of relief that is plausible on its face. And to make a claim plausible, the factual matter must allow the court to draw the reasonable inference that the defendant is liable for the misconduct as alleged. As this circuit recognized in McCleary-Evans v. Maryland Department of Transportation State Highway Administration, 780 F. 3rd, 582, Penn Site 585, a 2015 case from this circuit, at the motion to dismiss stage in an employment discrimination case, a plaintiff is merely required to allege facts to satisfy the elements of a cause of action created by the statute. An appellant, McCleary goes on to say, is not required to plead a prima facie case of discrimination under Title VII, and instead must raise a right to relief above the speculative level. Here, the district court in its opinion, and appellee in its brief, took issue seemingly with whether the appellant cited adverse actions, one, the denial of overtime, was an adverse action pursuant to Element 3, and two, whether similarly situated employees who were outside of appellant's protected class were treated more fairly, Element 4. Here, it is our position that the district court scrutinized the pleadings beyond a threshold pleading standard of plausibility and made impermissible comparator assessments at this pleading stage in favor of the appellee, which adversely impacted both appellant's race discrimination claim and her retaliation claim.
How long there was a trial board here, and the judgment of the trial board went against your client. And how long was the trial board proceeding? How long did that take, the actual hearing?
If the hearing was scheduled for 2 days, Your Honor. I was not counsel at that proceeding, but I'm aware that it was a 2-day schedule.
It took 2 days?
Correct, that's my understanding, that it was scheduled for
Okay,
2 days.
was the trial board proceeding a fair one?
According to Ms. Johnson, it was not. And as we cited in our complaint, there were many.
What was wrong with the trial board proceeding?
Well, Your Honor, let me correct myself. In terms of the administration, if you will, of the trial board proceeding, I don't believe that that's my client's position. I believe her position is that there was evidence that came out during the trial board, which to your question about Judge Wilkinson, what was wrong with it, was the fact that there was one, a detective that apparently made false statements that were contradicted by the record, and we do cite to this in our amended complaint. And two, that
Well,
there
I
was.
mean, obviously, any trial board or trial court would have to resolve some inconsistencies among the competing testimony, and would have to make some kind of resolution of it the same way a district court would have to make. But the charges here, and Judge Bennett was looking at it, and the charges here against M.S. Johnson were number 1 for assault and number 2 for failure to notify our supervisors about these incidents and for making false statements on 2 separate occasions. And then the district court goes through the different comparators and says that the other comparators were very different, and that charges were never filed, or I forget, one of these, you made a particular point of having Mr. Cushaw be one of the comparators, and the district court says that Judge Bennett says, while plaintiff insists that Cushaw made false statements and provided false testimony, he was never charged for such conduct, nor were such charges considered by a trial board. Accordingly, Cushaw is not an appropriate comparator, and he did this with respect to each of these supposed comparators and showed in what instance they were different here. And said that they did not all involve charges sustained by the trial board for 3 different things: assault, failing to notify supervisors, and making false statements during the course of the investigation. And so I think that one of the difficult things you have here is what went on, is the fact that the trial board ruled adversely to you, and that the supposed comparators didn't really, some of them involved different circumstances.
Thank you for your question, Judge Wilkinson. So first, I would posture that the district court's decision did not go into the level of detail with all of the comparators, 12 that were cited as it relates to essentially.
12 were cited in the complaint?
Yes, Your Honor.
Go ahead, I'm sorry.
Judge King, yes. 12 were cited in the complaint as it relates specifically to the constructive discharge claim. And then 4 were cited as it relates to the specific overtime claim, or what we would call the denial of overtime, or lack of permittance to, for her to engage in overtime claim. So Judge Wilkinson, to your question, we would note that the district court also considered Baltimore Police Department's policy 310, which is essentially their disciplinary policy. And you can find that notation to the court's reference at JA 092. And what we would purport is that here, what we're arguing is that there was disproportionate penalty towards the appellant in this matter in comparison, which was not accounted for by the district court in its analysis, and which, quite frankly, could not really be assessed without discovery. And so we would posture that the district court stepped into really an inappropriate trier of fact role beyond
Because
more
we're
than.
at the 12B6 stage, where we're looking at the comparators, and we do have case law that says there's, even on the merits, the comparators don't have to be a one-on-one match, correct?
That's correct, Your Honor.
And is Coolshaw the one that was convicted of assault?
Correct, Your Honor, which again brings us to part of the issue. So while perhaps the department chose not, for whatever reason, which could potentially be explored in discovery should we get that far, for not pursuing charges or trial board charges against him, which, Judge Wilkinson, just to go back, is actually a state law issue. It's not really a federal law issue. So technically, Ms. Johnson does have rights, and officers generally have rights to appeal a trial board decision to the next step. And then there would be a circuit court ruling as to whether or not the final decision was proper or appropriate or not. But however, because the appellant in this matter resigned, that kind of analysis ends, so we don't actually know what the state court would have indicated as to whether or not the trial board was in fact proper. But yes, Your Honor, there is case law which we have also cited to Mitchell v. Toledo Hospital. It's a Sixth Circuit case, but it's also referencing the Fourth Circuit 2017 case of Swasso v. Onslow County Board of Education, where, to your point, Judge Thacker, the comparators just need to have sufficient commonalities that would allow a jury to reach an inference of discrimination. And because we're talking about juries, this certainly, both of these cases do
Well,
not
we're
really.
not talking about juries yet. We're just at the 12B6 stage, so you don't need a whole lot of specificity or looking behind the complaint.
Absolutely, Your Honor. I was just referencing the Swasso decision. And because Swasso, as well as the Mitchell v. Toledo Hospital, a Sixth Circuit case, which we cite in our brief on page 18 and 16 respectively, those were dispositive motions, meaning beyond the 12B6 pleading stage, Judge Thacker, to your point. And so if we're talking about inferences of discrimination to reach a jury, this is certainly beyond the scope of where we are right now at the 12B6 pleading stage.
Well, I don't think there's any contention that the altercation outside of Norma Jean's nightclub reflected favorably upon the police department. I mean, you simply don't want police officers of whatever rank or whatever engaging in the kind of conduct that took place outside of this nightclub. And Baltimore had some real problems of all kinds of nature about the behavior of its police department. And I think they, in this case, they were interested in seemed to be interested in dismissing and imposing discipline against someone who was engaged in this kind of misconduct. And one of the things that struck me here was that the Baltimore authorities didn't just go off without carefully considering the evidence. They just didn't. They did not shoot from the hip. These whole proceedings, as I understand it, the investigation and the trial and everything, they took quite a bit of time, didn't they? I mean, from the time of the altercation to the time of the final trial board decision was something like a 3-year process. So it didn't seem to me that this was a situation where someone headed in for somebody else. And it also seemed to me a situation where very, very often in a 12B6 situation, you don't have the advantage of a trial court proceeding or a trial board proceeding that took an investigation that took a number of years, apparently, to complete, and a trial board proceeding which went on for several days, and issued adverse findings. And of course, we know that 12B6, you don't get quick shoot from the hip dismissals, but here this was behavior that did not reflect favorably upon the police force, and these people did not shoot from the hip. The authorities did not shoot from the hip. They took a lot of time investigating it. They were faced with 3 different charges of false statements and failures to notify supervisors and assault. And I just don't know why. I think there's some advantage in allowing this very, very troubled police department to impose discipline of someone on somebody who was involved in an altercation that simply don't reflect standards of police conduct the way we would all want. Part of the problem is that the police in many cities are just on the loose, and that results in many instances in racially discriminatory behavior on the part of the police. But in this case, you seem to have a situation where their conduct simply doesn't reflect the kind of behavior we would like to see in all of the metropolitan police departments, many of which badly need reform because of, in my judgment, racially discriminatory actions.
Thank you for the question, Judge. So first, I just want to make it very clear for the panel that this is not actually a situation where Ms. Johnson, in fact, engaged in the conduct as it was alleged and charged.
Let me ask some questions in that regard. Sergeant Kusel is the one who was convicted of assault for what
That's correct.
happened at the club that night, correct?
That's correct, Your Honor.
And how was he disciplined by the police department?
I don't know that he was disciplined at all, to be quite honest, Your Honor. Perhaps that's a question the department can answer, but nevertheless, my understanding is he still, in fact, to this day, works for the department.
And with respect to appellant, the Office of the State's Attorney declined to prosecute her, correct?
That's correct, Your Honor.
And she was fired.
Correct, Your Honor. And to that point, Your Honor, going back to Judge Wilkinson's question, I think if Your Honors look to JA 50, JA 51, JA 52, JA 53, JA 54, you will see that there are at least 16 different examples of conduct by officers, sergeants, and lieutenants who respectfully, seemingly engaged in way more severe and egregious and in conduct that would have the department in general in disrepute versus the quote-unquote alleged false statement that Ms. Johnson supposedly engaged in, which body-worn camera indicates is not true, which the internal affairs investigations that are recorded indicates is not true.
And the state's attorney declined to prosecute.
Correct.
And in fact used her as a witness in the prosecution of Mr. Cushaw.
Correct,
And was
Your
that
Honor.
prosecution upheld
It was.
on appeal?
My understanding is it was. And that is potentially why he is still working there. But nevertheless, he was not, to Your Honor's point, subjected to the disciplinary proceeding. And I know my time is running short, but I do just want to address the timeline issue. So here, Your Honor, the department does in fact take quite a lot of time to actually investigate these cases. In fact, they're supposed to be charging people within a year and a day of the alleged offense. Here, it took 3 years for something to come full circle. So really, what happened is, once the appellant testified in January of 2019, this is prior to her also having her overtime request blocked.
And you're saying when she testified against Officer Cushaw,
Officer Cushaw in favor
who
of
the
the
jury
same.
convicted?
Correct, yes. And then on September 2019, the proceedings were held, and this is in our, on page 5 and 6 of our brief specifically, of our brief specifically. It talks about the fact that he was found guilty of assault October of 2019. He did file a appeal of this guilty verdict. Apparently, he was suspended and placed on supervised probation pending the appeal of his verdict.
He
and-
wasn't fired after he was convicted of assault?
Correct. It says appellee ultimately chose not to pursue his removal. And so the melee, Judge Wilkinson, that you're referencing was actually caused by Sergeant Cushaw. It was not caused by the appellant. What actually happened was the two women that were originally starting this situation came into the private space and were advised that they were in a private space, a reserved space in this nightclub. And they, in turn, began to, get loud or have this commotion caused. It was not the appellant in this case, Ms. Johnson, who was the aggressor. She did not assault anyone. She was alleged to have assaulted someone, but even when you go back into the investigative file and see that it was actually subsequent interviews of those two alleged assailants.
It wasn't just the assault, it was the false statements.
Correct, and we would purport that that's not true
that
either.
She was accused of making false statements during the investigation, so the authorities here felt that she was not being forthright and honest with them, that she was making false statements and that she was lying or misleading the authorities during the course of the investigation. And one thing I would say is that you can't ask a police department to, they want to operate on in a medium of trust, where they trust what officers are telling them. And in this instance, they were making, the problem with her was she undermined the trust that people could have in her in two ways. Her supervisors were never once notified of the incident, and false statements were given on 2 separate occasions about the incident. And you can't have a department where someone is misleading other people within the department, making false statements, failing to notify people of incidents involving. You have to have police officers notifying their superiors of incidents so that corrective action can be taken. And you have to have police officers making truthful statements to those around them. And a police department cannot operate in the absence of trust. And the trust was undermined in 2 specific ways. And that just doesn't lead to the kind of environment that the public is looking for on the part of police. There has to be a certain internal integrity to it, and that was what was absent here.
Your Honor, if I may respond to that, because I understand that my time is short. Specifically, Your Honor, to that point, the department still has officers, to your point of trust, who have used the N-word to applicants for employment, who have been found guilty of DUIs, who have actually assaulted people, who have been found drunk and disorderly at a bar. This is JA 51. Just some examples. There are different domestic assaults where you have officers in relationships with one another assaulting each other. You have sustained uses of force to members of the public, where officers are beating up members of Baltimore community. And so absolutely, I agree, Your Honor, you absolutely should not have officers engaging in this type of conduct. But a false statement and compared to a DUI and compared which endangers the livelihood of the Baltimoreans and other passerbyers on the street, a department that has sergeants who are found disorderly and drunk outside of a bar, such as Major Kiera Saunders, a white female, JA 51. Also, you have Major James Hanley, who called apparently, allegedly, an applicant a effing N-word, JA 50. You also have lieutenants with sustained DUI cases. And so it goes on and on. And so to your point, Judge Wilkinson, we would agree. You should not have these type of members in the department. But if you're not going to have these type of members in the department, make sure you have all of these members who engage in more egregious conduct than a false statement, such as a DUI, such as domestic violence and abuse.
I wonder how, because I see that with metropolitan police departments, I see they have a lot of problems. And I think there's a lot of problems with police work. But the question is, how are we going to reform these things? We want there to be equitable treatment of everyone, absolutely. But on the other hand, when you throw up such obstacles to an effort to say this individual, because of this altercation and because of false statements and because of failure to notify people, when you say, well, no, we're not going to dismiss the case at this stage, notwithstanding the careful analysis of the district judge, you really are making it more difficult to get to where we want to be, and that is, I think, a police department that treats all of its citizens equitably, and also within the department itself has a mutuality of trust that will enable the department to function effectively. I think that you and I share a common interest in seeing these departments improve and be more racially fair, and they're not. And there are an awful lot of instances where black citizens are treated unfairly by police departments, and we share that. And that's why I do understand where you're coming from, and I respect it a great deal. But I'm also thinking at it from my perspective, that there has to be some kind of internal trust involved if we're going to get beyond step one and step two in trying to make police departments better for all concerned. And so, but I'm not at all antagonistic about this, but I do think there's a critical question of internal operation and mutual trust, without which a department, nobody can function. No corporation, no company can function if subordinates are not reporting incidents to superiors, and if people are making false statements. You can't have any company function with that kind of situation, which lowers morale on the part of everyone. And police departments, in that sense, they're no different. They're no different from a corporation that has to rely on employees being truthful with it. That's all I'm saying.
If I may respond, Judge?
Absolutely.
I agree with you 100%, but this is not a situation where there was something that occurred in a silo and Ms. Johnson's supervisor was not aware. This was a responded to incident in a public street, really, where you already had a sergeant who apparently went viral, I know that's not in our brief, for beating this other officer in the face. This was well known widely throughout the department. It was widely known throughout the Baltimore community, and quite frankly, because it went viral on social media, because there was a recording of this, it was well known throughout the country.
That's right, but the chain of command still requires a report, and so from that point, you get the individual's view of it when they report it, and they can write it up, and they can set the wheels in motion, and they want her views, so you do rely on reporting it.
But she was an off-duty officer. She was in the time, she was not working in the scope of her position as a police officer, and you may say, well, just like being a lawyer, you are always a lawyer, you're always a police officer, but this is not a situation of something that occurred when she was at work, when she was performing the duties of her responsibility as a Baltimore
All right.
police officer.
I want to say how much I appreciate your argument, and you've also reserved some time for rebuttal, but I want to ask my colleagues if they have any questions of you. Talk.
Thank you, Judge.
Not right now.
Stephanie, do you have further
No,
questions?
thank you.
All right, thank you very much.
Thank you, Your Honors. Thank you, Judge King.
Ms. White.
Good morning, Your Honors, and may it please the Court. My name is Christine White, and along with my colleague Natalie Amato, I represent the appellee of the Baltimore Police Department. Counsel for Ms. Johnson would have this Court believe that this case is far more complex than it really is. In fact, this is a straightforward dismissal of an amended complaint for failure to state a plausible claim of entitlement to relief. Ms. Johnson
There are
challenges—
3 claims.
Correct, Your Honor. There were 5 before the district court, and Ms. Johnson has appealed 3 of those rulings by the district court. Neither of those 3 claims, neither of those rulings that Ms. Johnson challenges warrants reversal by this court. So as to the claim of Title VII race-based discrimination, whether the inability to work overtime is an adverse employment action is really immaterial, because the discrimination claim ultimately fails due to the fact that Ms. Johnson failed to present sufficient factual allegations from which a court could reasonably infer that her proposed comparators were similarly situated.
Really? I mean, there's a whole list, there's 12 of them, some with a variety of different allegations of misconduct laid out there, and we are at the 12B6 stage, which does not require an inordinate amount of specificity, and beyond that, our case law holds that there doesn't have to be a one-on-one match of comparators. not at the, not even at the merit stage, so certainly not at the 12B6 stage, I wouldn't imagine.
Correct, Your Honor, and we don't disagree with the legal standard. What we believe is the facts that have been alleged do not satisfy that legal standard.
What more could you want 24 comparators that have engaged in a variety of similar crimes with different outcomes?
Well, Your Honor, respectfully, I would say
It's
that-
almost enough to have one comparator, the one who was there and was convicted of assault, and then what happened? His conviction was confirmed?
So, yes, Your Honor, he was convicted of
Where-
second-degree assault.
And did he, like appellant, he must have gotten terminated then for that, right?
He was not terminated, Your Honor. I will
So
point
what,
out.
so he was treated differently for being convicted of assault?
Well, Your Honor, I will point out, and counsel for Ms. Johnson has
He
represented
doesn't still work
this.
at the police department,
He does, Your Honor.
He what?
It's my
He does?
understanding.
He
it's-
does?
Correct, Your Honor.
Wow.
It's my understanding that Sergeant Kushal does still work for the
So
Baltimore
he
Police
was
Department.
convicted of the assault that started this whole thing?
Yes, Your Honor, he
Appellant
was.
testified against him at his trial in order to achieve the conviction on behalf of the state. And then it was affirmed on appeal. He still works for the police department, and appellant was terminated. And the prosecutor declined to prosecute her for anything, correct?
That's my understanding. There was a declination letter, correct.
This makes no sense.
Well, Your Honor, what I will point
Unless there's some sort of, it makes enough sense for there to be sufficient comparators in this complaint at a 12B6 stage.
Your Honor, what I think is important with respect to Sergeant Kushal, and this is a representation that of which the court can take judicial notice, and it's a representation that counsel for Ms. Johnson has made in another case that she filed against the police department. Sergeant Kushal is black. He is not outside the class of individuals with the same
But he's a
protected
man,
identity.
so he's not a black woman.
That's correct, Your
As
Honor.
appellant is. Were there any civil suits filed against Sergeant Kushal as a result of this incident?
There was a suit against the Baltimore Police Department and Sergeant Kushal, correct.
And what happened to that?
That lawsuit was in the federal court in the District of Maryland, and there was a jury verdict against Sergeant Kushal.
For how much?
It was $5.2 million.
5 point what? 2
I
million?
believe it was $5.2 million.
And he still works there?
It is my understanding that Sergeant
But this
Kushal-
complaint isn't sufficient to get beyond the 12B6 stage?
For a claim of racial
Right,
discrimination,
for a
no,
claim
Your
of
Honor,
racial
it's not.
discrimination. Okay.
I
Or
would-
for a claim of retaliation?
Well, with
Let's go to the
retaliation.
next one, retaliation.
Sure, and with retaliation, what I'll point out is that this is a Title VII case. Title VII protected activity is pretty specific in what it relates to. It relates to either participation in a Title VII-based related proceeding or opposing practices that an individual reasonably believes or that are unlawful under Title VII. The only protected activity that happened here was in February of 2021 when Ms. Johnson filed her complaint with the EEOC. By February of 2021, Ms. Johnson was well aware that the Baltimore Police Department was seeking the termination of her employment.
That
for
goes to
having-
the temporal issue
Correct, Your Honor.
that appellant arguably has with regard, the challenge that she has with regard to the retaliation claim. Opposing counsel said, I might have gotten this wrong, but I thought I heard her say something like the process was supposed to take no longer than 1 year and 1 day, and for some reason it took over 3 years. Is that?
So, Your Honor,
Could you respond to that?
Yes, and I'm sorry for interrupting, Your Honor. I'm glad that you brought that up. It was a point that I wanted to make. And so, generally, an officer needs to be charged within 1 year and 1 day. In this instance, there was a pending investigation by the state's attorney's office, and so the 1 year and 1 day did not start until the first declination letter was issued, which was June 14th, 2019. I'll also note that this issue of I won't say the sufficiency, I'll call it the timing of the internal investigation and bringing the charges, that was already litigated in Maryland State Court. Ms. Johnson was charged.
If you're going to retaliate against somebody, it doesn't take 2 years to do it.
Well,
Unless,
that's correct, Your Honor, and you
I mean,
also.
all I'm saying is that retaliation is often swift and immediate. And if you're going to retaliate, you wouldn't spend 2 years going through something.
Certainly 2 years breaks the causal connection time link in some pretty significant ways. I think to your point, Judge Thacker, to the extent that perhaps the investigation and the length of it may have been unfair in some way, that issue was already litigated before the Maryland state courts. And contrary to the representations in Ms. Johnson's opening brief, the appellate court of Maryland reversed the state circuit court's decision with respect to the timing of bringing the charges and ruled that the charges against Ms. Johnson could go forward. They did rule that the charges against her husband were time barred, and so her husband, Mr. Marcus Johnson, was not investigated for that.
You know, it's disappointing that I think that this is somehow turned into a racial issue when there's no dispute that the altercation that took place that evening outside the nightclub was simply not good police work in any way, shape, or form. And when you combine the fact that the altercation itself was the kind of thing that would undermine confidence in the police department, and then you couple that with the ensuing problems that took place during the investigations, failure to notify initially, and then false statements after that. And you combine those two elements, the unseemly altercation outside of Norma Jean's and the prevarication and misleading conduct that took place during the investigation of it. It cannot be that a police department is disabled somehow from taking disciplinary action or taking action only after years and years of litigation. It cannot be that these obstacles would be placed in the hands in front of authorities who I hope are trying to, and there's some evidence that the police department in Baltimore is aware of the problems, and they're serious problems, and there's some evidence that it's trying to eliminate those and improve the conduct of the department. And I just worry about the fact that courts are making that kind of effort at reform considerably more difficult.
Well, thank you, Your Honor. I would point out that I think there is quite a bit of evidence that the Baltimore Police Department is trying to move away from the past and move forward, and is making quite a bit of progress, has made quite a bit of progress. I think what's really important to point out when we're talking about the comparators, because that seems to be something that the bench is particularly interested in, is that
What bothers me with respect to these comparators, as well as the whole complaint, is the 12B6, we're supposed to accept them as, the allegations as true. We're obliged to, in the standard of 12B6. At this stage, even though the conversation here, or the arguments sound as if there's been full discovery in this case, and there hasn't been any.
Well, I think, Your Honor, that, and correct, we are supposed to take the allegations as true. With respect to the allegations.
So you accept the allegations as true?
We must accept the allegations
There
as
you
true.
go.
so
Okay.
then there are at least six alleged comparators that are alleged to have made false statements or failed to report incidents that were not terminated. Why aren't those sufficient comparators in a complaint at a 12B6 stage?
Well, we need to talk about the rank of the individuals, and when we look down to appropriate comparators, we can't compare majors to officers. They're subject to different forms of discipline and the disciplinary matrix as it applies to officers.
That sounds like you're saying we have to have a one-on-one identical comparison and they have to all be the same rank. And we agreed earlier, I thought, that the case law says that can't be. That is not the law.
I agree that, and absolutely, Your Honor, the case law is that there does not need to be a one-on-one comparison, but there do need to be meaningful comparisons.
The impression is being left that the comparators were not disciplined in any way, shape, or form, and that's not correct. The comparators in some cases were demoted, had it noted on their record. It wasn't as if the so-called comparators got off scot-free. They didn't, did they?
I think talking about just in general the number of the comparators in a vacuum can make this conversation a little bit more confusing, a little bit more complex.
And that's what discovery is for, and that's why at this stage it's more lenient in terms of Twombly and Iqbal and what needs to be pled.
Well, respectfully, Your Honor, I would say when we look at the possible comparators, certainly looking at comparators, the two
And we
white
accept the
female
allegations of the complaint, well-pleaded allegations of the complaint as being true,
Correct. Yes, we accept them as
not
true.
as being contradicted, but as being true.
Just having two comparators, however, and I'm referring to the two white female officers who were charged with false statements. They're at the Joint Appendix 51. There was a trial board hearing that was dismissed. A trial board hearing can be dismissed for a number of reasons. It could be because the officer pled guilty. It could be because the officer pled to a lower offense. It could be because the officer was eligible for retirement and chose to retire. And so simply knowing...
Again, that's what discovery is about, and there's not just two white female officers alleged as comparators for false statements. There's at least 4 others that are male officers, and then, I mean, there's multiple allegations other than just the false statements and the disparate treatment.
Well, when we look at conduct, and that's particularly important here because conduct is what led to this discipline. The disciplinary matrix that applies, that the Baltimore Police Department has, rates different offenses differently. And while
And that might all be very, you might prevail going forward with all of this level of detail you want to get into, but we're at a 12B6 stage where we're looking at the complaint. And on the face of the complaint, I'm not sure why these comparators aren't sufficient, but I would like to hear more about your argument on we haven't heard anything, I don't think, from you on Monell.
Correct, Your Honor.
Could you, in your time, talk about that?
Absolutely, Your Honor. One more point, if I may, with respect to the comparators at the 12B6 stage. Just because something might appear to be consistent with discrimination doesn't mean it supports a reasonable inference. And I'll point to McCleary-Evans, and I'll point to cases before this court that have cited McCleary-Evans favorably, being Brevo, 959 F3rd 605, Seabrook, 148 F4th 264. The fact that there might be 2 people who perhaps received more favorable treatment or does not support on its own.
We're seeming to jump to a conclusion that, of course, there's discrimination here. Let me mention this whole point about discovery. The discovery here, I just don't think it's enough to say, well, this is 12B6. The discovery here would, I underestimated it by saying months. It would take years. It would be on and on and on, and voluminous and voluminous and voluminous. And if you're trying to get to reform things within a police department, that discipline and dismissal for untoward conduct is better and more effective if it can be immediate. If it's going to be only after 4 or 5 years or however long it takes to go through all of this discovery, which we know from innumerable sources and academicians, is becoming a more and more laborious process. And in the interim, what is being lost is the fact that discipline within a police department on the basis of what seems to be a fair trial process, that the immediacy of the discipline, which makes it more effective, is going to be lost simply after years and years of discovery and litigation, or months and months, or however long it takes. The question is here whether whether the authorities faced with undisputed evidence, and this is, take it true, the undisputed evidence here is critical when looking at the complaint, and that is there was an unseemly altercation outside Norma Jean's nightclub, and as far as I know, there hasn't been brought into any kind of genuine dispute or whatever the fact that say, oh no, all of these statements that were given were perfectly truthful. And you can take a great deal and under 12b-6, a great many of these facts that are listed in the complaint, and there are a great many things in here that are undisputed, and you can take them as true. You can take them as perfectly true, and you can say, well, there's still this altercation outside the nightclub, and there's still the problem of prevarication during the course of the investigation. You see what I'm saying?
I do, Your Honor, and thank you. And I will just note before I discuss the Monell claim that false statement is, it's a police officer, no police officer can perform the essential functions of his or her job duty if they don't have integrity. False statement is an integrity violation, and the Baltimore Police Department simply has to take false statement charges seriously because it affects our officers' ability to perform their job functions and testify in court.
But not assault charges.
Your Honor, Sergeant Kushel does still work for the department, that's
Mhm.
correct.
And your Monell argument?
Yes, Your
I suspect you
Honor.
have a
So-
solid argument there.
Well, with respect to the Monell claim, in this case, Ms. Johnson has brought a condonation claim. A condonation claim, Monell claim, simply cannot survive at the 12b-6 stage based solely on the appellant's own personal experience and reference to the 2016 Department of Justice report. Several courts, it hasn't come before this court, but several judges of the district court have noted that counsel's reference to the 2016 DOJ report as alleged sufficient factual allegations to support a Monell claim have been and are legally insufficient. This is a claim, this is an argument that we have seen from counsel several times before. Counsel was provided the opportunity to amend her Monell claim and failed to do so. And the law is crystal clear that this court cannot allow a Monell claim to go forward based on those kinds of allegations.
Well, your basic point, which you made earlier, that a police department simply has to take false statements and prevarication very seriously, and I haven't seen that brought into, I haven't seen that brought into any kind of dispute, that these were false statements.
I believe that Ms. Johnson disputed that before her trial
Oh,
board.
I know
She did
that.
she did have a trial board, and the trial board did find her
But I'm talking about the trial court findings, the trial board's findings.
Correct, yes, Your Honor.
And that's, that's the, we can say we need discovery and everything, but you already have a proceeding here. That you don't have a situation where most complaints don't come with an adjudicatory proceeding underlying them. And in this case, you have a complaint, but you have an adjudicatory proceeding underlying it, and prior to the time that the complaint was filed. And you have findings from the trial court board that there were false statements made during the course of the investigation. Those are findings after a 2-day hearing, and considerable discovery and interviews and things that went on before the 2-day hearing. And if this complaint were just, taken off if that hadn't been present, this would be a different case for me. But the problem I'm having here is that when you have a prior hearing, a prior adjudicatory proceeding, and you have factual findings by the trial board that false statements have been made, and that there has been misleading within misleading investigators and superiors within the department, that has to be taken seriously. And this takes this complaint out of the usual 12b6 kind of reaction, because this complaint has an adjudicatory proceeding, a trial board proceeding, which took place prior. And you don't have that in so many other cases.
Thank you, Your Honor. I think what that goes to is moving from the possibility of consistent with discrimination to raising a reasonable inference of discrimination. If Your Honors have any other questions, I'd be happy to answer them, but otherwise we would respectfully submit on our briefs, and the Baltimore Police Department would ask that you affirm the lower court's decision. Thank you.
Thank you. Ms. Lewis, we're happy to hear from you in rebuttal.
Yes, thank you, Your Honor. There's so much I'd like to say
I
because...
think you've dropped some
Drop
of
a
your
piece of paper there.
papers. I don't want you to.
Yes, so thank you, Your Honor. There's so much I'd like to say specifically to some of the points you raised, Judge Wilkinson. First, it's important to recognize that a trial board decision is actually not binding on the department. And so while I certainly understand your argument, it's actually the police commissioner's final decision, and then subsequent to that, if there's an appeal, like I mentioned before, the PG County Circuit Court's decision that then subsequently becomes binding on the department. A trial board, yes, is an adjudicative process made up primarily of police officers. So in this case, if you have a situation where one of your fellow brothers and sisters in blue are going against the grain, I mean, I think living in America, we understand how that works. You are now immediately putting a target on your back when you go against your brothers and sisters in blue. That is largely what we believe undercuts this entire thing. So it's not just the fact
And you
that
mean, so by going against
Sergeant
the other
Cushall.
officers, you mean testifying
Correct.
at Sergeant Cushall's trial?
That's correct.
At which he was ultimately convicted?
Yes, and so going back to that, Judge Wilkinson, related to the temporal proximity argument, here you have to look at the totality of the circumstances. She essentially, the appellant that is, put a target on her back by testifying, Judge Thacker, against Sergeant Cushall in September of 2019. Then she's denied overtime. Then she complains internally about the fact that she's denied overtime. Then she files a February 16, 2021 EEOC charge. Then she files an internal complaint related to investigators making false statements against her. She follows up several times then about that investigation, which ultimately those supposed charges of false statements were not sustained. Then she receives the declination letters from the state attorney's office, and then she is charged for
But
false statement.
given the timing of it, were those responsible for the plaintiff's termination? Did they even know of the internal complaint and the EEOC charge? It seems to me that the internal affairs complaint and the EEOC charge were filed significantly prior to the investigation and dismissal?
It's related, Your Honor, specifically to the fact that she put a target on her back when she testified in January 2019 against Sergeant Couchal.
But were the people who were responsible for the plaintiff's termination, did they even know of the internal complaint?
So respectfully, Your Honor, two things. One, I think these are fact-based inquiries that are not appropriate for a motion to dismiss pleading stage. These are more appropriate for a merits argument.
So you don't know if
So
they knew or not?
I don't know because I was not counsel related to.
How could we make a reasonable inference to connect to those based on the complaint alone?
Because ultimately, it's the police commissioner that makes the final decision related to the termination. And so here, the police commissioner is the Mecca, if you will, so to speak colloquially, the Mecca. So that is the final decision. And so as it relates to these various charging decisions, and again, just referencing the fact that the district court did look at Policy 310, which is the department's policy matrix related to disciplinary procedures, there is disproportionate and differential treatment as it relates to all the comparators here, including Ms. Johnson, who specifically, we argue and purport, is distinctively different by race and other protected characteristics from the other individuals who were not in fact terminated. And just to note the fact of what Sergeant Couchal's racial identity is, we actually don't fully know. All I can assert is what my clients tell me. We know he is a dark-skinned man. We don't know, because we've not been through discovery, what he actually identifies. He could be Asian, he could be Hispanic, he's a darker brown-skinned man. So yes, according to Ms. Johnson, he is not Black or African-American, but he is a browner-skinned man. He could be Hawaiian. So just because someone, as we know in America, has a darker complexion does not automatically make them Black or Black identifying. So I do think that is important to note that for the record. Additionally, as it relates to the Monell claims, we do believe in our brief as well as in our complaints, we have cited to specific instances, and I can read you those paragraphs of where the Baltimore Police Department does in fact have a practice and custom. If you look at JA 66 through JA 68, specifically in our amended complaint, paragraph 79, 141, 142, 144, 152, and 153. These are all, in our position and posture, assertions of the practices that the Baltimore Police Department engages in that would make a Monell claim at this stage survive a pleading 12B6 stage. And so, for example—
Practices with respect to its dealings with the general population, or with respect to
Officers, Your Honor.
officers?
With officers, Your Honor.
That's in, where is that?
Yes, Your Honor.
Is that in
So
the DOJ report?
that specifically is not. What's in the DOJ report is about the culture of retaliation as it relates to civilians in Baltimore. And
Right,
so
and that
there-
is more the general population and not the police department. I
Correct.
was looking for something specific to the police department.
Yes, understood, Your Honor. They are under constant monitoring, but for whatever reason, the Department of Justice has not monitor them for how they treat their own employees, which is a part of the issue here that we would purport. And so in terms of just going back to some of the other points that were made, we agree, Judge Wilkinson, that the department should be taking fair action, but it should not be taking unfair action when there is differences in protected characteristics. And that is our position as the appellant. Additionally, because you must accept these allegations as true, these differing factual inquiries that we've been having a very robust dialogue about from our posture exceeds the 12B6 pleading threshold. Additionally, as you called it, Judge Wilkinson, the unseemly altercation was started by a person that still works at the department. And I think that we cannot overlook that fact. Yes, we absolutely want to rid police departments, not just in Baltimore, but across the country, from bad and poor behaving officers, because inevitably that treatment and those experiences and conduct bleed into their constituents and the community residents that they are policing. But we cannot—
Counsel?
Yes, my time. Thank you. I thank you all for
Your
your
time is up, but all I can say is we appreciate the commitment you have to your case.
Thank you. Thank you.
Let me just make sure that my colleagues are satisfied. Are you okay with this?
I'm good.
Yeah, I don't have any questions.
Thank you, Your Honors, for your
All right,
time.
we thank you, and let's adjourn court, and then we'll come down and say howdy.